appeal but heard in the matter of Gas and Electricity Markets Authority and SSE Generation Ltd.
Please the court, I appear yet again on behalf of SSE.
Yes.
My learned friends, Ms Rogers appears for GEMA, and Mr Hickman Casey and Mr Brown appear for the CMA.
Yeah.
So the representation is slightly different, but I'm afraid you're still stuck with me.
Yeah.
For the purposes of today's resumed hearing, with your Lordship's permission, what I propose to deal with is the issue of liaison with the EU Commission.
Yeah.
Then the issue of retained EU law.
We have read everything you've sent us, although we were slightly perturbed at the quantity of material that seems to have been generated by two short points. But just to say at the outset that we have read everything, and that we would expect this hearing to be relatively short, Mr. Hugh. An absolute outer limit, and I emphasise those words, of an hour and a half.
I will cut my cloth accordingly. On the issue of liaison with the EU, I should say the third issue will be disclosure issues, and then I've got some very short concluding reply points because my reply was not quite finished last time round in July, but they will be, I promise, very short. On the role of the Commission, our position is set out in the note, and your Lordships have read it. That's at paragraphs 7 to 13, paragraph 40, and paragraph 50. I don't propose to say much more than the note sets out what we say are the mechanisms that could be used. The CMA has taken a point at paragraphs 24 and 25 that the withdrawal agreement doesn't apply. With the greatest respect, we think that's wrong. It's a matter of timing. The decision from GEMA was issued on the 17th of December 2020. That was within the transition or implementation period. There was an obligation on the UK and GEMA as a state entity to apply EU law until the end of the implementation period. See section 1A of the European Union Withdrawal Act 2018. If your Lordships note, that's Bundle of Authorities 1, tab 6, page 205. And the deleted subsections that are referred to there simply maintained in effect the European Communities Act 1972 until the 31st of December 2020. So EU law still applied. If it's really being suggested that GEMA didn't take into account EU law, then with respect, that was a mistake. That was an error of law because it applied in full force and effect, and the retained EU law was not applicable at that date. It hadn't yet been brought into force. So the law that we're dealing with is the recast regulation, and it's the recast regulation that should have been applied. Now, happily, the submission that seems to be advanced is at odds with the decisions that were taken. So the GEMA decision at Hearing Bundle, Supplemental Bundle 2, tab 14, page 271, noted that the 2019 recast regulation had replaced the definition of ancillary service and recognised that it was that definition that ought to be, in principle, to be applied. What GEMA did, of course, was to say that they didn't think the meaning of the word ancillary service in the ITC regulation had been changed by that subsequent legislation. That's very different from saying, in principle, the recast regulation doesn't apply, and GEMA never took that point. In any event, the CMA in its decision recognised that the definition of congestion management had to be derived from the recast regulation. And for your Lordship's note, that's from paragraph 8.53 to paragraph 8.54, Core Bundle 3, tab 24, page 709. So both GEMA and the CMA recognised that EU law applied, they recognised that the recast regulation had to be applied, and they differed as to how they were to construe that in the context of the ITC regulation. And you have my submissions on that construction of that regulation. I'm not proposing to repeat those. In terms of the withdrawal agreement, this is dealt with, my lords, in the supplemental bundle of material that was served by GEMA. Page 35 of that material sets out the withdrawal agreement. In short, if I can just give you the headline points. Article 4 says that EU law is retained during the implementation period and still applies, and that includes the direct application of regulations. Article 5 contains the good faith clause that we've cited in the note, and Article 6.1 then contains an updating provision saying any updated EU law should be applied during the transition period. Now that applies here because the 2009 electricity regulation was replaced with the recast regulation during that period. It entered into effect, I think, from 1st of January 2020. So we then see in Article 127 at page 41, EU law is applicable in the UK during the transition period, and at page 45, Article 162 assigns a role to the EU Commission. That, we say, would be a basis for approaching the EU Commission and saying, would you like to give us some assistance on the correct construction of the term congestion management, if the court feels it needs it.
If we decided we needed it, we could either invoke some sort of legal or quasi-legal right, or we could simply, as a matter of comity, make a polite request to them for their assistance without risking getting into any form of legal dispute or debate with the Commission, which may not be a very sensible thing to do. So really the question for us is whether we should do it, and if so, what value we would get from them, given where we are now.
Yes.
And one of the things, I mean, you've alluded to the point already, and in one sense it's right, this is an appeal from the judicial review which relates to a decision taken at a particular point in time. So that would logically focus us upon the 2019 recast regulation. On the other hand, we give a judgment at a point in time when we've departed the EU. Are we logically, sensibly, pragmatically going to ignore what's said in the EU retained law?
Well, my lord, the answer to the legal issue as to what is the applicable legislation that the court is being invited to construe is the recast regulation. I recognise that in practice that may have a knock-on impact on the construction of retained EU law, but ultimately that isn't for now.
The view of the judge was that the EU retained law and the 2019 regulation were the same thing. And that was the view, I think, of
CMA.
CMA. And we might or might not agree with that. Now, if we agree with it, it all becomes academic and irrelevant. If we don't agree with that, then we have to decide whether give a judgment which is pure archaeology, or whether we do something which is more up to date and pragmatic.
My lord, it's not entirely pure archaeology because it would potentially impact on past years prior to the adoption of the retained EU law.
Yeah.
So it would have an impact in
We'd
practice.
have to do both. We may have to express a view on the interpretation of the 2019 recast and a view on the interpretation of the retained EU.
If I could perhaps, with respect, put it a little higher than that, given that our appeal is against the construction of the recast regulation, which was a valid issue before the judge below, and the judge gave a judgment on it, and this is our appeal for which we've been given permission. I think that nettle does have to be grasped.
Yes.
The alternative, of course, to treating them both as being equivalent to 2009 and that being in accordance with the judges and the CMA's conclusion,
Yes.
is the conclusion I'd urge upon you, which is the opposite, which is that properly construed, the 2019 recast regulation simply confirmed the position as it had always been, namely that congestion encompasses internal congestion and congestion on the interconnector, albeit that the focus of the EU instrument has necessarily been on the cross-border impact, because that's what the ITC
We
regulation...
recall those submissions, and we've got to decide whether what happened between 2009 and 2019 was such that there were deliberate changes made to the definition in the 2019 regulation, where they removed, excised any reference to international trade or interconnectors and used different terminology. But that's, in a sense, ground we've traversed already.
Yes, I mean, my primary submission is that 2009 regulation is capable of being construed as to include congestion on a transmission network because of the disjunctive use of the word and or, 2009, replicated in the retained EU legislation by simply or. But what they're seeking to deal with is congestion. Congestion causes a problem on the transmission network. The transmission network is connected to an interconnector. The definition, the word that's actually used in the 2009 regulation is interconnection, when it's talking about the connection between those two pieces of infrastructure. It's not using the word interconnector. So when it's talking about trade across an interconnection, it's talking about a piece of infrastructure that is both transmission network and the cable or wire that connects two different transmission networks, namely the interconnector.
Well, it's an interconnection linking national transmission networks. So it's something which is between two national networks. But I mean, that's all gone. That terminology disappeared in the 2019.
Yes. My primary submission to your lordships is GEMA's decision was taken in December 2020. The recast regulation applied. It's the recast definition that has to be applied.
We understand.
Just as a matter of form, Northern Ireland Protocol also has provisions we've set out in the notes, and there is a good faith clause in Article 3 of the TCA, coupled with some energy provisions in the TCA. So all of that could be prayed in aid should your lordships wish it. Now, should your lordships ask for help, well, we're in the court's hands really on that. You will see in due course that there is a view expressed by ACER, which is the energy regulator that is the specialist regulator in this field, that the definition of congestion for ancillary services purposes should include internal congestion and congestion on interconnectors. So the expert body at EU level takes a different view of the construction of congestion than that is pressed upon this court by GEMA. So on any view, there is clearly a risk of divergent interpretation between this country and the EU in the event that GEMA's construction prevails on this appeal. That will, of course, impact on the competitiveness of GB generation, for the simple reason that the bundle of charges that go into the pot for the purposes of the ITC calculation will have stripped out those charges that relate to congestion management, and they are heavy charges that are imposed for congestion management under the SSE regime. It will also lead to a discrepancy in our submission between the position that applies in Northern Ireland and the position that applies in GB, which is not to be welcome. So, on balance, we would suggest that avoiding a divergent construction between the EU and the GB charging network, particularly given the delicate position of Northern Ireland, is to be welcomed. If contacting the EU Commission is likely to resolve that divergence, or at least assist with resolving that divergence, then it is to be encouraged in our submission. And the fact that there will be some modest delay associated with that shouldn't determine whether or not the right answer is determined in this court. But beyond that, I'm not sure I can greatly assist this court as to whether it should, in the exercise of its discretion, invoke that power. Can I then deal, please, with retained EU law? You have my submission that retained EU law was not applicable or in force at the time of the decision, and indeed that is what is confirmed in the CMA decision, paragraph 8.32. That's Core Bundle 3, tab 24, page 704. I don't actually remember that proposition being subject to a direct challenge before Mr. Justice Swift. I think GEMA's case has always been almost the last submission of the day, and by the way, this is also consistent with retained EU law. I'm not aware of a submission being advanced that retained EU law at any stage has applied at the time of the decision. Now, in keeping with my Lord Justice Green, transcript day 2, page 30, from the 19th of July hearing, we respectfully suggest that retained EU law should be construed to give one meaning consistently with the underlying EU law that is being retained. And what my Lord said was, just as a matter of commercial, technical, engineering reality, we are interconnected. We need to have the same rule as everyone else in Europe. And we respectfully agree with that. We also contend that the Secretary of State evidently thought so as well, because he did not think that EU law, when it was retained, was making any substantive change. Now, before turning to the explanatory materials, could I please just do a quick analysis of the terms of the recast regulation that were in fact retained? And this involves turning up in Bundle of Authorities 1, tab 8, page 372, the retained legislation. That's Bundle of Authorities 1, tab 8, page 372. This is the definitions section introduced by a new Article 2. It doesn't have the breakdown of subparagraphs, and it reorders the definitions so that they're in alphabetical. Starting, if we may please, on page 372, ancillary service, we see that the Secretary of State has retained, through this delegated legislation, secondary legislation, a definition which meets that set by a combination of the recast directive and the recast regulation. And so ancillary services is defined to exclude congestion management. Now, in contrast, balancing services are defined as ancillary services, as are non-frequency ancillary services. If one turns to page 374, one finds the definition by the second hole punch of non-frequency ancillary services, meaning a service used by a transmission system operator or distribution system operator, steady state voltage control, fast reactive current injection, inertia for local grid stability, short circuit current, black start capability, and island operation capability. So those are all what are described as non-frequency ancillary services. Frequency ancillary services would be balancing services because they are designed to maintain the frequency of the electrical transmission over the transmission network to keep it balanced and therefore capable of safe operation. Could we turn back please to page 372, where your lordships will see a whole lexicon of balancing terms. So balancing is itself defined. There's balancing energy, balancing service provider, and so on. So there is a separate lexicography for balancing. Bidding zone is retained as a definition. And then we see capacity allocation is defined as the attribution of cross-zonal capacity. Congestion, at the top of page 373, has the definition that this course is now very familiar with. You have my submission that yes, whilst it replicates to a large extent the 2009 definition found in Article 22C, the 2009 regulation, it doesn't, we suggest, differ in substance from the definition of congestion found in the 2019 regulation, because it is
This is where the problems arise, because what's happened is they've taken a repealed provision from the 2009 regulation. It was repealed by Article 70 of the recast, and they have Brexitized that instead of Brexitizing Article 2.4 of the recast. But yet it's said that it's the same as Article 2.4 of the recast, when in one view plainly it isn't, because it reinserts all the words which were taken out when the 2019 recast was formulated.
The 2019 definition talks about network areas which aren't defined, but at least highly arguable that includes congestion within a national system for whatever reason. But the definition in the EU retained provision couldn't possibly bear that meaning, could it?
Well,
it's clearly dealing with the position between countries.
In our respectful submission, it can be construed in a way that is in keeping still with the 2019 concept of congestion, because one focuses
linking the GB transmission network with the transmission network of another country or territory.
Because one focuses on the fact that the congestion that is arising is on the transmission system concerned, and that congestion gives rise to a situation, a circumstance, in which not all trade flows of electricity, international trade flows, can move across an interconnection. And it's interconnection, not interconnector. So the concept is
interconnection linking GB to another country. I understand why you made the argument. The difficulty is, in a sense, for whatever reason, which somewhat escapes me, what they've done is take the old repealed definition and Brexitize that, even though what they really wanted to do was Brexitize the Article 2.4 of the recast. Yeah. And we're left with this problem. I mean, I don't know if we'll get there or not, but even if you're right on 2.4 of the recast, and even if it were eminently desirable to achieve consistency for the reasons that you've specified, what happens if we just simply can't, as a matter of language, construe the EU retained? And constitutionally, we heard there's lots of discussion between civil servants and others, but we can't take that into account. We've just got to look at the words and be very, very rigorous about applying those words. If we take, you may be right about the 2019 being the operative piece of legislation for the purpose of the decision. If we have to look at this subsequent EU retained law, we've got to be very, very careful about what we take into account, how we construe it. given that it's EU retained law, and the government has the right to change, depart.
But if it follows a correct statutory procedure for doing so. And the short answer to my Lord's point is you don't need to construe the retained EU legislation because it wasn't applicable at the time of the decision.
Yeah.
So that would make it somebody else's
That's
problem. If you were to express an opinion on it, it would therefore be overturned. If you were to express an opinion on it that it was inconsistent with the 29 recast regulation, then my submission as a follow-up is, well, that would make it ultra vires, because the express wording of Section 8 is to cure deficiencies. The definition of congestion given by Article 2.4 wouldn't be a deficiency. It's perfectly capable of being applied domestically in a sensible way as reflecting internal congestion and congestion on an interconnector. There's no logical reason why congestion that arises only on one piece of an interconnected system is going to define congestion full stop. And that's a point that the ACER expert has made. So if we're in a world where this is a departure of meaning from the 2019 recast regulation, then the Minister hasn't achieved his expressed intention when he was talking to the delegated legislation committee of simply retaining EU law as it stands, save where there is a deficiency.
But that's all, that you may very well be right about that. But, that's not for this court.
No.
What we can do is say, you may be right, it's overturn, but say that, construing congestion as defined in the retained law provision, they've used the 2009 version, which means something different from the 2019 version, if that's what we conclude.
If that is your conclusion, they are indeed different definitions.
And then leave it to the government thereafter to do whatever they have to do to sort that out.
Yes.
Because they have the right to change the law. They may say, oh, well, yes, this is cock-up, not conspiracy, but actually we'll rethink, we'll retain it, we'll change it.
But they
I'm
can
not saying
change it.
we can't legislate. We've got to be really careful.
No,
It's
accept that.
not up to us to legislate.
No, it'd be constitutionally improper for this court to
Absolutely.
take a view on how it should be legislated. What this court can do is look at the vires for the provision that's invoked for making the delegated legislation, secondary legislation, see whether or not it's within the four corners of the Act that is conferring the power to legislate, and conclude on a challenge to this effect that it is or it isn't. But that's not for today. That's not for now. Obviously, if it turns out to be the position that a substantive change in definition has been made, and that has a material impact, which in my submission it would, then there should have been a procedure followed of consultation plus impact assessment. If that hasn't been followed, that would be another reason to nullify the delegated legislation.
Well, the reason for that, it may be inadmissible, but we now understand is that the relevant civil servants were all saying, well, it all means the same, the meaning hasn't changed.
Yes.
But I mean, that would no doubt explain why there wasn't any consultation, because they didn't think they were changing anything.
Yes.
But the issue for us, if it arises, is
Has it changed?
has it changed?
And you would be expressing a view, Obiter, as to whether or not, I mean, my learned friend's submission, Ms. Rogers' submission, is essentially, you can take comfort from the fact that this definition at face value seems to be supporting a narrower construction of congestion than one would find ordinarily on the natural and ordinary meaning of the 2019 recast regulation in Article 2.4. And I can see that argument. My response to it is, in fact, when you look at this retained EU legislation, it's not apparent to me that they thought they were changing the broader construction of congestion, because there are a host of references to congestion arising, which only makes sense if congestion includes internal congestion plus interconnector congestion. So it's very odd, and I accept there's an incongruity, and I accept it hasn't been explained very well, and that is something I'll have a mild moan about later. But the fact remains, how does this court deal with it? My submission to your lordships is, you don't need to make a ruling on the construction of this retained EU law because it wasn't applicable at the time of the decision.
No.
Can I move on just to make good my submission that bits of this don't make sense if one builds in a narrow construction to the term congestion, whereas one can construe congestion if one concentrates on the lack of capacity arising on the transmission system concerned, consistently with Article 2.4 of the recast regulation. So the way to do that would be to focus on the concept of congestion being a phenomenon that arises from a lack of capacity. That lack of capacity can be simply on the transmission system concerned, and then the oddity is the retention of a link to the concept of international trade, because that's actually unnecessary in a Brexit context, as my Lord Justice Green has indicated. And when we come on to see how some of the other provisions work, they ditch the whole concept of having a connection with the EU. So, for example, it's open now to generators to be constrained, for interconnectors to be constrained to enable domestic generation to have a fair crack of the whip in terms of capacity constraints. So that provision is gone. So there is a more insular interpretation of this legislation that is possible, and therefore to have the retention of the concept of international trade being relevant is odd, and I accept that. Counter trading.
Thinking about it, I can understand once we've left the EU, even if we're still part, as it were, economically, technically, an internal market, it still is for us legally international trade. What is slightly more difficult to understand is why one then has congestion management only limited to the interconnecting between the states element, as opposed to that which might be said to flow from Article 2.4, which is a more broad brush view of where the blockage occurs. There are costs incurred. They have to be allocated in some way. The question is, are they an ancillary service or not?
Well, they've kept the concept of redispatching to deal with congestion. Redispatching can take place cross-border, it's true, but it predominantly takes place internally within an internal transmission network. How can you possibly have a reference to congestion that is interconnected congestion in that context? If I just deal with it logically, then I haven't missed anything, if I may. So I'm just going to take it in order. Counter trading, top of page 373, cross-zonal exchange initiated by system operators between two bidding zones. Well, as a matter of fact, at the moment, we don't have more than one bidding zone, but of course we could have two bidding zones in due course if Scotland were to become a separate country, or if Scotland simply adopted a different transmission network as it had before 2005.
Bidding zones were the areas between member states where you bid for capacity over an interconnector.
Either between member states or within a single member state.
Right.
That diagram I showed you from the Ofcom report, I think there were 4 or 5 with Italy.
It was simply it's the mechanism for allocating the capacity in the most economically efficient manner.
It's intended to be the obvious area within which constraint is not causing a problem.
Yeah.
Because otherwise you get physical boundaries to the free flow of electricity, which is problematic. Counter trading means cross-zonal exchange between two bidding zones to relieve physical congestion. So that brings with it this concept of physical congestion on the transmission networks being relieved through counter trading between two different bidding zones. And then similarly, cross-zonal capacity means the capability of interconnected system.
We went through all this last time. The real question is not, do you have interconnectors? Do you have congestion? It's a different question. It's how do you allocate the costs relating to those things? We've seen throughout there's a complicated system for dealing with congestion, but it's quite a different question how, as a matter of policy, you allocate the costs, whether into the transmission charge or otherwise. When on reflection, we weren't quite certain. There were 1 or 2 references in the travaux and in the legislation which gives some indication of how you allocate costs. But most of it is simply dealing with the mechanism which necessarily has to exist for dealing with congestion.
Well, the ITC mechanism is dealing with the impact of cross-border flows of electricity, which is somewhat different from congestion.
Yeah.
There is no mechanism by which there is a cross-border approach to congestion management.
Until 2019, it seems to have been left to the discretion of the individual regulatory authorities. I think 2019 was the first time there was an exercise of allocation spelled out in the legislation.
Yes, I mean that allocation, as we'll see here, that allocation now in the retained EU piece is both for allocation of transmission capacity within an internal network and also on the interconnector.
Yeah.
So it has both. Redispatching is defined at the top of page 375 as a measure including curtailments activated by 1 or more transmission system operators. Just pausing there, we currently have 3 transmission system operators in GB. There is an SSE entity, there is a Scottish Power entity, and there's a National Grid entity, and they have different spheres of network for which they are responsible for the operation. And that redispatching can be activated by 1 or more of them in order to change physical flows in the electricity system and relieve a physical congestion or otherwise ensure system security. So that's contemplating, in my submission, the ability to cut off supply or demand at one area, turn on supply or demand in another area, so to redispatch the generated flows in order to deal with physical congestion in the electricity system. And that can only mean congestion within the national transmission network, because otherwise it doesn't make sense. None of that is going to impact on interconnectors. The only thing that would impact on interconnectors would be redispatching cross-border, which is a separate concept. I'll come on to that in a moment. Will we then please turn to page 384. I'm going to make these points very lightly because you'll appreciate that they track the submissions you've already had from me. But I'm simply showing you that the retained EU piece retains these things. And the same arguments I made for the recast can therefore also be made here. Page 384 is balancing responsibility. That's separate from capacity allocation and it's separate from congestion management. 387, balancing market, same point. Page 407, Article 13, is the redispatching provisions. As I've indicated, this redispatching predominantly takes place within a single transmission network. And we see in Article 13.1 at the top of page 407, redispatching of generation and demand shall be based on objective, transparent, non-discriminatory criteria. Under subparagraph 3, non-market-based redispatching of generation may only be used where no market-based alternative is available. There's then an obligation to report to what is now the regulatory authority, which is the CMA, and under subparagraph C, the measures taken to reduce the need for downward redispatching of generating installations using renewable energy sources in the future, including investments in digitalisation of the grid infrastructure and in services that increase flexibility. So what's that talking about? It's talking about encouraging methods for redispatching that don't turn off renewable generation. Why are they doing that? Well, for climate change obligation purposes, you want as much energy to come from renewable sources as possible. So if you are going to adopt measures that reduce the need for downward redispatching of renewable sources, that's a good thing. And so they're trying to encourage reporting on digitalisation of the grid infrastructure. Why is that relevant? Well, we've seen that transmission network charges are predominantly based on the cost of the infrastructure of the network. Redispatching through digitalisation of network infrastructure. So instead of simply building out more infrastructure, you can have clever systems put in place through the Connect and Manage system that came in 2010, 2012, whereby market signals are sent out to discourage people from generating at certain times and to encourage other people to generate at certain times without needing to build more kit. And that's a way of avoiding the rollout of expensive infrastructure, but it's a means functionally of ensuring that constraint and bottlenecks are avoided. And so that shows that redispatching is very much conceived of as being part of the overall grid infrastructure proposals and projects. So why is that relevant? Well, because costs associated with grid infrastructure are paradigmatically generation charges. They're not ancillary services. And therefore, constraint management and redispatching is also, we say, functionally the same as that sort of cost. What we
This is
then
an argument which panders to economic logic, not necessarily the construction of words. I understand the point, but we've just simply got these wretched definitions to grapple with, whether they're economically logical or not.
It would be preferable if they were.
Well, it would be preferable if they were.
There is a concrete reference here to the digitalisation of the grid infrastructure, which in this context strongly suggests that it's dealing with network-related issues, and obviously the whole point of redispatching is to avoid network-related issues, which is a bottleneck in a particular part of the grid infrastructure. It's not dealing with balancing. Balancing is a separate section. That's my point. And so when Malone and Friends submissions all said, well, balancing is classically an ancillary service, and this is a type of balancing, I'm afraid that's simply not right. One only needs to read even the retained EU legislation to see that they are dealing with different things. We then see at page 412 that bidding zone review has been removed. So the concept of restructuring one's bidding zone to deal with structural congestion, physical congestion within a network has gone. But of course that is the sort of power that's open to Secretary of State to exercise as a matter of pure domestic law by restructuring the transmission networks if he considers it appropriate to do so. An important section is then Article 16, and I'd invite the court to read Article 16, 1, 2 and 4, page 417, if you'd be kind enough to do so. Bearing in mind that these are all provisions, we say, that apply equally to internal congestion as to congestion on the interconnector. And so every time if one sees the word congestion, one interpolates interconnector congestion. Does it make sense? Network congestion problems can't sensibly be construed simply as being interconnector congestion problems. Otherwise, the word interconnector congestion can't sensibly have been used, as it was when we come on later to look at Article 90, which is also being retained. We then see at subparagraph 4, the maximum level of capacity of the interconnections and the transmission networks affected by cross-border capacity shall be made available to market participants. So even in the concept of capacity allocation, it's dealing not simply with allocation on the capacity on the interconnector, but also the affected transmission networks. So you have to make everything available to enable counter trading and redispatch also to be used to increase capacity. Redispatching, I repeat, is not simply cross-border redispatch, because Article 16.4 includes cross-border redispatch in the process. So you would have the ability to exercise a redispatching power on a purely internal network to relieve internal congestion in order to free up capacity. And therefore it doesn't make sense in that context for congestion every time it arises to be implicitly preceded by the word interconnect. We then see in Article 16.6, again repeats that it's both capacity on the interconnector and capacity in the transmission network that will be up for grabs. Article 16.8 has not been retained, been deleted. What did that deal with? Well, that permitted, that declined to permit it, it prohibited the ability of TSOs to curtail interconnectors to deal with internal congestion. And so it is now, in theory, open to TSOs to shut off the tap on an interconnector in order to deal with internal congestion. Article 6.13 replaces the concept of congestion between bidding zones with something that is described as observed congestion. That's at the bottom of page 418. And observed congestion in this context must necessarily mean observed congestion arising both within the domestic transmission network and more generally on the interconnector. Otherwise, the remaining parts of the provision don't make much sense. At page 425, Article 18 remains substantially unchanged. And so you have all of my submissions from previously, recognising that network charges for access will include dealing with the costs of congestion. See Article 18.3. Now, interconnectors don't pay network access charges. Therefore, congestion solely on the interconnection, on the interconnector itself, is never going to give rise to a charge that will be levied against a generator per se, it's never going to give rise to a charge that will be levied on the interconnector. And therefore, when it's talking about dealing with network losses and congestion caused, it is necessarily contemplating congestion on the transmission network as a whole. Because it's the charges for the transmission network as a whole that are being levied on generators. Now that's also without prejudice. See over the page, top of page 416, to charges for network access, to charges resulting from congestion management referred to in Article 16. Now just in context, since charges levied on interconnectors aren't going to fall within the scope of this article, in order for it to be without prejudice, it has to be talking about charges for congestion management that will be levied on generators. Otherwise, there's simply no overlap. And therefore, the overlap must refer to charges for congestion management within the scope of Article 16.1 and 16.2 of this retained EU law piece. And so the definition of congestion, I repeat, breaks down if it is simply interconnector congestion. And in contrast, Article 19 is dealing with something called congestion income, and that is revenue associated with congestion management procedures. Revenue will be derived from the capacity auction process. Bids will be received to be able to get capacity. That produces an income. That can't, we say, sensibly be described as a cost. That gives rise to a charge.
Am I right? There's nothing in this which expressly deals with the allocation of the costs associated, but your argument is that it's consistent, that what one deduces from this is that congestion is recognised as occurring anywhere on a system, and one's moved really away from congestion as a blockage to international trade to congestion as a cost to be addressed on the internal broader market of the EU.
Exactly.
But that's essentially what this drives at. But there's nothing which explicitly addresses how you allocate the costs, as between the transmission charge or more generally.
No, the internal allocation of charges is very much for the regulator. What Article 18 does is it says, well, you're going to have charges applied by network operators for connection and use, related networking reinforcements, etc. But they have to be transparent, non-discriminatory, etc.
But you pray this in aid in effect in support of your broader interpretation of Article 2.4.
Yes. The point I'm
You
making...
simply say the system is consistent with your broader interpretation.
Yes. This is the parallel submission I made previously on the recast regulation.
We remember it.
But I'm showing your lordships, I hope, nothing's changed.
No, we remember that. We've got that point.
Article 19 deals with congestion income and uses in Article 19 2b express reference to interconnector congestion. That necessarily implies congestion as a broader concept. With respect, I'm not going to belabor the point. You've got my point that retained EU law won't make much sense if one adopts a narrow construction to congestion. You don't need to go there, but if you were to go there, then there is a way of dealing with it. And we accept that the legislative history was intended to, drafted initially to reflect the 2009 regulation. You'll have seen the explanatory memorandum to SI 2019-530, which is at page 19 of the material provided by GEMA. That was then updated, it never entered into force, and the key explanatory memorandum is therefore the one that we find at page 172 of the additional bundle of materials. And we see at page 172, my lords have that, paragraph 2.2. It's intending to amend directly applicable EU law, dated at the end of the IP period, to ensure it still works.
There's not much, I don't think there's a serious dispute between the parties, but that the retained EU measure was intended to establish continuity and be the same. The question is whether they achieved that purpose or whether they did something unintentionally different.
Yes, one sees at page 175, paragraph 7.1, 7.2, this instrument is intended to ensure relevant retained EU law, i.e. the recast regulation, remains operable. We will deal with deficiencies. They identify what the significant deficiencies are. There's no suggestion that amending constitution was the definition of congestion was perceived to be a deficiency. We see in 8.1 the invocation of the vires of section 8. And then we see in 10.1 there was no consultation beyond technical and factual input being provided by GEMA, Ofgem, its executive branch. And for your note, it's correct that Article 2 of the SI retained the definition that we've just looked at, and that's bundle of authorities 2, tab 12, page 633 is the relevant SI as published. But of course, what is, with respect, slightly extraordinary about this is so many of the definitions were updated. The definition of congestion wasn't updated, it was rolled back. And you will have seen the correspondence in which we asked for an explanation of that. I can take you to the references if you want me to, but in a nutshell, the Secretary of State said, well, he considered it remained appropriate. We've pushed on that, we've had nothing more. But in our submission, the clear intention was to retain the recast regulation save where there is a deficiency. Congestion doesn't give rise to a deficiency. It hasn't been identified as a deficiency. And therefore, the only way of squaring the circle would be to give it the broad interpretation that the recast regulation requires. If that isn't done, then that part of the recast regulation is unlawful. That, in a nutshell, is my submission. Now, in terms of disclosure, you will have seen that we asked for disclosure. Some has been given.
No, we have to be terribly careful about relying upon internal civil servants' notes.
Well, with the greatest respect, the response doesn't really make much sense in any event, because the first bit seems to suggest that they were deliberately trying to implement the 2009 regulation, which, if correct, would be unlawful. And the second note then seeks to explain that they're trying to implement both the 2009 regulation and the 2019 regulation, which doesn't make much sense either.
Maybe another reason for not relying on it. Yeah, I mean, people debate things. I mean, you know, my experience over the last 5 years in the law firm, I've seen a lot of internal debate and discussion, like all lawyers, 5 different lawyers all agreeing, disagreeing, having different views, gradually coming to a common view. At the end of the day, we can't look at that, can we?
What I'm inviting the court to do is not to rule on the retained EU law piece anyway.
I understand that.
Well, in which case this is all jolly interesting but wholly irrelevant.
Yes.
But the point my law's putting to you is that if we do grasp the nettle on EU retained law, we can't possibly look at what discussions took place internally between civil servants as to what they thought they were doing, because that's just totally inadmissible.
If that exercise of restraint, if I can put it that way, is applied equally to the suggestion from the Secretary of State that there was no difference between the 2009 regulation and the 2019 regulation.
That's the point of view that the expressing can, no doubt, maybe a view Mr. Hickman or Ms. Rogers urges upon us. But
with respect, I don't see why that would be
if we grapple with the nettle, we have to decide whether it means the same or whether it's different.
Well, an explanatory memorandum, for example, that which you've just taken to us two, are admissible.
Yes.
Yeah.
So, you know, we're in early days of retained EU law, and we just need to be quite principled about the way we approach this.
Yes.
When, I think for reasons which really don't need to be spelled out.
It's sufficient for my purposes that you have my submission that the way of construing what the legislature was intending to do with what was done is to confer a broad interpretation on the retained EU law definition of congestion. If that can't be done, then it's broken. Simple as that. That's enough for my purposes. Can I deal with the disclosure that was given? Because we do say it's interesting, because it goes to the divergence point. And what we have is a view expressed by an individual ASA. This is at page 56.
Well, they support your view.
We suggest that they support our construction.
Yeah.
Page 56, not of the GEMA material, sorry, of the material that was passed up by my clients and Adelshaw Goddard. That was a separate clip of correspondence. I hope my lords have that. If not, I think it was also included in the GEMA material. Page 56, I hope the court has a series of emails Could we pick it up, please, in reverse order as characteristically with emails, and start at the end? At the bottom of the page, page 56, there's an email that begins, "Hi, Jan." The court has that. It's from James Stone of National Grid to an individual, Mr. Jan Kostovich at ACER. ACER is the regulator. It's the cross-border agency set up under an EU regulation that is in charge of monitoring compliance with, amongst others, the ITC regulation guidelines. See Article 32 of the recast regulation. Bundle of Authorities 1, tab 7, page 326. Mr. Kostovich, page 56, is approached by National Grids asking if he's well. He's then asked for review at page 57 on the basis of recent industry discussions with some generators raising the topic of ancillary services exclusion from the cap. From speaking to Martin, it says, "We've had some clarity that congestion management in the European context relates to cross-border flows, i.e. flows of electricity across an interconnector. However, we would like to now understand how the CEP should be interpreted regarding recovery of congestion costs through setting of network tariffs. The key items we would like to discuss are," and he then gives a question about whether or not ancillary services excluding congestion management relates simply to congestion over an interconnector, or whether it also encompasses internal congestion management, i.e. GB system constraints, and that's the word that's used. His response is then set out for the rest of the page. Please could I invite the court to read the rest of that response, and then I'll make some short points on it. So the points he makes are essentially these. One, it's a question of construction. True it is that the EU focus has been on cross-border because it's dealing with, for reasons of subsidiarity, it has to deal with internal trade, it has to deal with cross-border flows, otherwise it doesn't have a justification for intervening, but it's a question of construction. Ancillary services are not restricted to interconnectors, so you don't find ancillary services only provided in relation to the flow of electricity over an interconnector. So it makes no sense to restrict the concept of exclusions to ancillary services to interconnectors only. I add, interconnectors do not pay generation charges. 3, there was no evidence of a legislative intention to confine it to interconnector congestion. And fourthly, costs incurred in managing internal congestion and interconnector congestion should be included within the concept of congestion management, in his view. Now, he was the person who was approached by National Grid, seemingly as the person within ACER who would have the relevant experience and or knowledge. GEMA are seeking to take a point that he wasn't a lawyer. It's a regulatory agency giving an official answer to an official question from a TSO in a member state at a time when we were still within in EU law territory. And it's a view. That view was communicated to Ms. Harman of Ofgem. At the top of the page 56, we see it was sent to her on the 30th of September 2020. And your lordships will have appreciated that when one looks at the actual decision GEMA took.
And this is, again, it's just the view of the civil servant. I mean, we could read it as the view of the lawyer who's gone into, it's published something. It's not a guide to interpretation, it's an interesting view at best.
Well, my lord, it's slightly more than that, because it is the body that is responsible for monitoring the ITC guidelines, binding guidelines.
It's his musings. I mean, if we wanted to get the view of the Commission, wouldn't we have to do that formally? I'm not saying it may have some limited value, but he doesn't necessarily reflect the considered view of the Commission. He might or might not do.
It's not the Commission, it's ACER, so it's a separate body. But it is a body that reports to the Commission, and it's charged with reporting to the Commission on the issue of compliance with the ITC guidelines. And the definition of the ancillary service exclusion is in the ITC guideline.
Is he expressing a view at all on what the proper interpretation is? I thought in the middle of his answer, he says there's a legal gap. Both interpretations are possible. Careful analysis would be needed to clearly support one or the other. And then he goes on to talk about the spirit.
He talks about the spirit and he talks about the practical consequences of it.
So what's he actually expressing a view on?
Well, he's expressing a view on how, as a matter of EU an EU approach to construction, you would look at the purpose and spirit of the regulation in order to work out what the teleology required you to do.
He says careful analysis of the electricity regulation and directive would be needed to clearly support one or the other, and then he doesn't engage in that. He goes on to a different point, which is to say spirit.
Yeah.
That's quite common, I'm afraid, in Luxembourg.
Well, it may be, but what use are we supposed to do?
It's a precious little assistance.
Well, what are we doing? I mean, we're not just saying what's the spirit of this, are we?
Well, I'm not making a submission, it's about the vibe of the thing, which is an Australian concept of submission. But my submission is that as a matter of canon of construction of EU law, and this is one of them, then approaching what the purpose of the legislation is a standard means of statutory construction.
But we do that from the recitals,
Yes.
which you've taken us to. We do that from the body of the legislation, which you've taken us to. We do that from the specific language. We do that from the drafting technique and the history of the drafting. Those are the standard canons of
What we don't
interpretation.
do, though, is it's the opinion of an EU functionary.
It is an opinion of an EU functionary and a specialist body that is charged with monitoring. and
That's as
reporting.
maybe, Mr. Beale, but the fact is it's still in the opinion of the EU functionary.
My lord, I raised this submission because I hope I made it clear that this goes to the issue of is there a risk of divergent construction of the recast regulation?
Yeah.
So I think I can pray it in aid for that purpose. I'm not seeking to suggest it as a formal guide to the statutory construction of the recast regulation, if that helps.
Right.
It was, however, forwarded on to Ms Harman at GEMA prior to the decision being taken, and you've got my submission that the GEMA decision in Legal Annex 1 confirms that constraint management would be within the scope of congestion under the recast regulation. So the GEMA decision that is benefiting from this advisory email is consistent with the view that is taken in this advisory email. And certainly there's no evidence that it was followed up with a suggestion that it was wrong and you're not a lawyer.
Just looking at the time.
Yes, the second piece of disclosure that was given is at page 55, and an individual at National Grid, Mike Oxenham, makes a point in October 2019 to a variety of people in place, principally, I think, I can't see a GEMA reference specifically, but I may be wrong, that if a definition of congestion is defined in retained EU law, and I haven't seen the underlying legislation, but if one assumes that this is a draft piece of EU legislation that then mirrors the ultimate retained EU law, then the second bullet suggests that it's a narrower interpretation because it's moving from something more general to something more specific to cross-border flows. And again, I simply point out that it appears that this question of definition and this question of to what extent is it being changed was at least before the relevant legislative body, in the sense of an email was sent to Bayes and it was raised as an issue, and we are where we are. I simply can't explain what I accept as an apparent incongruity. My best point, frankly, is that it's not for this court to decide.
Yep.
Now, I think I did have some points by way of reply, but I seem to have covered most of them. You've got my submissions from previously that interconnector is between two member states. Bidding zone is a defined term, and the recast regulation deals with network areas, which isn't a defined term. I think I went through the Travo for the recast regulation previously and made the point that nowhere in the Travo for the 2019 recast regulation is there a recognition that congestion management is an ancillary service. So I appreciate that that's the drawing of a white silhouette around the body rather than the body itself, but it is not lumped in with the concept of ancillary services. And we say that simply reflects the fact that constraint management was never an ancillary service. Ancillary services are things like frequency, balancing, reserve power and stability measures. Those are services procured by the market and paid for by Grid, and Grid then recharges those charges to generators. And this is dealt with in the evidence of Mr. Graham at second witness statement, paragraph 16, and Mr. Mott at paragraph 7. GEMA in their submissions, I didn't quite get to make this point last time round, I'll make it in 2 seconds, GEMA in their submission concentrated on the capacity allocation method and said, well, that's all to do with congestion management. They simply glossed over, if I may say so, Articles 16.1 and 16.2 that I've taken the court to this morning in the retained EU law. And therefore, those provisions dealing with redispatching aren't simply to do with the capacity allocation mechanism. They're broader. My final point, subject to anyone tugging my gown, is that both the CMA and GEMA in their submissions alighted on locational charging as being an apparent rationale for their construction. With the greatest respect, this isn't what the ITC regulation is about. The ITC regulation was doing two things. Firstly, it was setting up an inter-transmission network compensation mechanism, which is gone. And secondly, it was adopting a measure of soft harmonisation of generator charges. It was doing both those things to improve cross-border flows of electricity. That was the purpose. The soft harmonisation was there to try and provide a level playing field to the extent possible for generators between different EU member states. That rationale has nothing to do with locational charging. As it happens, there is locational charging in the GB charging system for TNUOS charges, the transmission charges for network. There is also locational charging for network losses, which are recovered through the BSC charges, the balancing and settlement charges in the BSC regime. In contrast, the SUOS charges that we're dealing with here that relate to constraint management aren't locational. Now, as it happens, they could be, but they're not at the moment. So with the greatest respect, the locational justification for the construction that GEMA has urged upon this court simply doesn't sit with what actually happens, nor does it sit with what we say is the proper analysis of the travaux préparatoire that went into the measures in issue. My Lords, I'm sorry for indulging your patience longer than I needed to. There's nothing further from behind me, so unless your Lordships have any questions, those are my submissions.
Thank you very much, Mr. Hill. Would anybody like to say anything on the 2 points we raised, Ms. Rogers?
My lord.
Because the last bit we've been listening to was, I think, the balance of Mr. Field's reply from the last occasion, although I think one or two of the points were familiar.
My lords, I've taken it in that spirit, and I'm certainly not
Yes.
intending to go back over any of the material we addressed in July.
Yea or nay?
My lords, with your permission, I was proposing to address first the question whether the court should approach the Commission for assistance.
Yea or nay?
Nay.
Right.
Second, my lords, what your lordship should make of the retained law materials that are now before your lordship, and you'll have seen my submission is they support the submissions I made to you in July. And finally, and only to the extent you wish me to address it, the points that Mr. Beale has made as to disclosure and the emails passing between civil servants.
Well, speaking for myself, I'm not going to be assisted by any further submissions about the disclosure.
Okay.
We've made it perfectly clear that we don't think it's admissible material.
I'll say nothing further, my lords. On the question, my lords, whether the court should make an approach to the Commission, the critical questions, I say, are twofold. One, is the Commission likely to answer questions from this court? And two, if so, does the possibility of that answer justify the inevitable delay that the process will entail for the resolution of this appeal? I say likely, my lord, on the first question. Mr. Hickman will address the question whether there is arguably an obligation on the Commission to respond. I'm proceeding on the basis that it would be a matter of choice.
I mean, I think if we went down that route, I don't think we want to put ourselves or the Commission in the position of having to take a legal position on their relationship with the domestic court. I think our inclination would be that we would invoke some degree of mutual respect and comity and make an invitation, because we really wouldn't want to get into a situation where we've brokered some form of dispute between ourselves and the Commission as to jurisdiction.
Precisely, my lord. And the way your lordship put it to me in the summer was simply the Commission might say, well, as a matter of comity, we might choose to cooperate with an international court, and were the court to proceed, that is, in my submission, precisely the basis on which it should do so.
Yeah.
What I'd forgotten in July, and what the court did not know, was that the Commission had already been asked to intervene in these proceedings.
Yeah, we saw that.
And as your lordships have seen, we
But
know
that was by SCS, I think, wasn't it?
by SSE, by Mr
SSE,
Beale's clients. That's right, my lord. And your lordships will have seen from the correspondence, and I won't take you back to it, that SSE made precisely the points to the Commission that Mr Beale has been urging on your lordships as to the desirability of input to ensure the uniform interpretation of the relevant terms. And your lordships have seen also the Commission's considered response to that invitation, which is twofold. First, that it did not consider the legal risk associated with these proceedings, so far as the Commission and the EU is concerned, to be significant. It saw that risk as limited. And secondly, that it considered it had other mechanisms if it perceived there to be a problem as matters went forward. And on that twofold basis,
Trade and cooperation.
indeed, and the withdrawal agreement.
And what certainly would arise, but that perhaps is by the by.
Now, my lord, we could argue over the merits of that response, right or wrong. It is the considered approach
their
of the
response.
Commission to the points that Mr
So
Beale has
you
been
say
articulating.
the idea that they're going to adopt a different approach, even if the approach comes from the court,
Precisely,
is
right.
unreal,
Precisely. Conceivably possible, yes. Likely, absolutely not.
in which case the delays would not be appropriate.
Precisely, my lord. And if I can unpack that delay a little bit, just in real world terms, my lord, the Commission would obviously need to consider any approach from this court. It would need to consider the arguments and materials that this court has received in order to take an informed view.
My
and
guess
provide
is from experience,
assistance.
we'd be looking between 3 to 4 months, possibly longer.
At a minimum, my lord. I mean, it may wish to go to other member states for input on whether it should respond, if so, in what terms. I don't think it's uncharitable to suggest it would be at least that period and potentially longer. Mr Beale would say, well, so what, in a nutshell? It's more important that this court has all of the assistance it could possibly have available to it. But with respect, my lords, this is a case in which delay has practical consequence, and can I just unpack that a little? Ultimately, well, in fact, your lordships asked Mr Beale in the summer, what are the economics of this appeal? What's going on behind the scenes here? And ultimately the question is, in this jurisdiction, who pays those internal balancing costs which we've been arguing about? Do they fall to generators, or do they fall instead on suppliers? Demand, as they're called in the jargon. And if Mr Beale succeeds on his cross appeal, my lords, what we anticipate will happen, and with no criticism of his clients, is that they will say, well, we've paid all of these sums that should have been capped. Those should have been charged to suppliers instead, and there should be some reconciliation process. Arguments, no doubt, as to whether that's right and what it means and how it takes effect. But in practical terms, my lords, it means that suppliers in this industry are living with the possibility of that future reconciliation and the possibility of substantial further charges at some future point. Do they hedge for them? Do they price them into consumer contracts? There's a whole world of commercial considerations that flow from that, which would be difficult at any time, but in particular in circumstances in which it is widely recognised, I think, that these are volatile and difficult times in the energy markets as a whole. And so in my submission, the consequence, my lord, is that any unnecessary or any delay that isn't essential in this litigation is problematic and it is undesirable. And then I invite the court, my lords, to ask this question. Even if the Commission were to respond, is it likely that its response will transform the legal landscape on this appeal? And it's worth considering that in 2 stages, because one possibility is that the court were to ask the Commission for assistance as to the factual practice in other member states. Now, in fact, as you'll have seen from the joint note, we know from one of the impact assessments that there were only 9 member states at the time of the impact assessment for which this would be a live question at all. Only 9 member states who passed these charges to generators to some extent. So it's a small pool of potential comparators. But in any event, my lords, the practice in those member states will not answer the question for your lordships, which is what this legislation requires, any more than that it's open to me to say, well, the established practice in GB for however many years has been to treat these charges in X way. The position's the same, my lords. It will not answer the question of interpretation which your lordships will have to grapple. The other possibility is that the court were to pose a question to the Commission as to the proper interpretation of the EU legislative instruments. But the difficulty there, my lords, is that the Commission isn't an authoritative source of guidance as to the interpretation of European law. Its submissions would have no more weight than any other party to the appeal, and we would inevitably be in territory where the parties felt the need to respond to what the Commission had said, and a further round and a further round. And so your lordships can see in practical terms how that plays through. So I say, my lords, one, it's unlikely the Commission would respond. Two, if it did so, it is very unlikely that the answers it gave would really transform the legal landscape before your lordships. And three, the price of an invitation to the Commission to participate in these proceedings is delay which is wholly undesirable if it can be avoided. So for those reasons, my lords, I do urge you not to pass this to the Commission. Turning then to retained law, my Lord Justice Green asked 3 questions at the end of the July hearing. Essentially, what changed and by what mechanism? That was question 1. How does the position in Great Britain now compare with the position in Northern Ireland? That was question 2. And essentially, what should the court do with that material when it comes to looking at the questions before you? Question 3. The first and second questions, my lords, are addressed in the joint note. Mr. Beale has taken you through some of that chronology and from your lordship's interventions. I wasn't proposing to go back over that material unless you'd like me to do so. The critical question is obviously, what does this amended definition in retained law signify in the context of this appeal? And my short submission, my lord, is twofold. First, and for the reasons I outlined at the hearing in July, the definition of congestion that you find in the retained law instruments is clearly and unequivocally focused on congestion at an interconnector. It is not concerned and cannot properly be read as extending to all congestion anywhere within Great Britain. That's the submission I made in July, and I won't reiterate it. My lords, given that parties are agreed that that definition was intended to give effect to the position as it stood in European law at the point at which it came into place, there was not intended to be any change, that supports and is consonant in my submission with GEMA's fundamental case, as I outlined in the summer, that all of these definitions of congestion from 2009 through to 2019, through to the retained law version you have
This is
before
tail
you.
wagging the chien, isn't it?
In a very major way.
Well, my lords, to a degree that's obviously right. You can't look at the retained law as an aid to the interpretation of the 29
No, but if you
legislation.
start with,
I say it gives
looking at
comfort.
2009 and 2019, and you form the view that 2019 clearly changed things, you can't then use the EU retained law definition to say, well, hang on a moment, that view that I formed about what 2019 means is wrong.
I accept that.
Because much more likely is that somebody's made a mistake, because this was all done in an unholy rush.
My lord, was the court to form the view that the 2019 definition had intentionally and fundamentally changed the concept of congestion, then it would follow that that is your lordship's conclusion as to the effect of the 29 legislation. Retained law won't change that position one way or the other.
No.
But I do say, as you stand back from the materials, it is striking that if I am right as to what these definitions mean, there is a consistent theme that runs throughout the period.
Then I'll answer this. Why did the legislature take out of the 2019 definition in Article 2.4 any reference to either interconnectors or international trade? What was the purpose by excising those particular concepts and replacing them with broader, different, undefined language? Why did they do that?
Well, the short answer, my lord, in my submission is that from the perspective of Great Britain, there is no material difference. Because if you ask this, the 2019 definition...
We can't look at it from our... We've got to look at it as an EU measure.
It's EU directive.
I'm so sorry, my lord, I misunderstood the
Sorry,
question.
the recast regulation 2019, you compare that with the 2009 regulation, and the difference over those 10 years, we see from the recitals to the recast, that the legislature took the view that there'd been quite a fundamental change in the dynamics of the market. It was less nationally based, more unified single market based. they therefore took out of Article 2.4 any reference to either international trade or interconnector, which had been in the earlier 2009 version. So the question is, why did they remove those concepts of international trade when they recast the definition in 2019?
My lord, the answer to that is this. The changes in the market between 2009 and 2019 were a process that resulted in a series of bidding zones, as your lordships heard in the summer. Some of those were coterminous with member states, some were wider than a single member state, some were smaller than a single member state. And the specific congestion management process known as capacity allocation, with which in my submission these measures are concerned, was operated as between bidding zones. And so when you look at what's being done in the 2019 definition, my lord, is it's an updating of the position. You're no longer concerned simply with interconnections between individual member states. You're concerned with congestion at links between the different bidding zones, different network areas by which the electricity markets are then constructed.
That might be within a single member state or within a conglomeration of 2 or 3 states who've got together to create a single market. It's no longer interconnection at a national border.
That's right, my lord, but it's congestion at the interconnection between those specific network
It
areas.
doesn't say that in the 2019. It talks about, I mean, the definition is network elements, isn't it? Which,
Network areas, my lord.
well,
Well, network elements.
the blockage in the new definition. It's both.
It's requests to trade between network areas, that's the way it's said.
Cannot be accommodated because this would significantly affect the physical flows of network elements which cannot accommodate those flows. So network elements, that's the nearest they come to interconnectors. That's the replacement word, isn't it?
Network areas, I think, unless
Well, no, network areas is the countries or the blocks or the zones. It's the
I'm following network elements
physical
in the
flows
second part,
on
yes.
elements. So that could be, for example, an element transmitting electricity between Scotland and England, or France and the Netherlands, or Netherlands and the UK. And that's the only word which I think in 2.4 which could be a reflection of interconnector is network elements which cannot accommodate. It's the blockage. It can't be accommodate. You can't accommodate the trade because there's a blockage on that element.
But the critical first part of that answer, my
But
lord,
that could
is,
be international or internal, that's the point.
and under the 2019 definition, you were looking at requests between network areas that can't be accommodated. And in my
We were talking about, I think, in the 2019 it was between, it wasn't just network areas, was it? It was international. Sorry, 2019, yes, that's right. 2009 was international. So the international, in other words, trade between 2 legal entities, 2 states, has gone. In other words, the legislator has said we're no longer just looking at an internal market that we're trying to create with lots and lots of legal boundaries between transmission areas. We've now got, as they described in recital 3, that there'd been the most profound change in decades, which had led to new forms of consumer participation and cross-border cooperation. So we moved from the purely national to something which was much more international. At least this is your opponent's view, that as a result of that, they had to reconfigure their analysis of what congestion was and where it occurred. It was no longer relevant to just limit it to the international between 2 legal entities, but it could be more internal.
My lord, that gives rise to this question, which is the question for the court.
Yes.
When you're looking at this definition in 2019, have the EU brought in all forms of congestion anywhere within a member state within this definition? Is that the true extent of it? Or is it some subset of that? Is it some different category of congestion, and if so, what?
Yes.
Starting point, my lords, I say, as I said in July, it cannot be read as encompassing absolutely all forms of congestion anywhere in a member state. It is plainly a more specific and targeted definition than that. Now,
I wonder if there may be a high element of regulatory discretion as to what amounts to congestion. Not every tiny blockage. It may be, there's no definition of really what's meant by congestion. It significantly affects physical flows is the definition here. But that may be a matter for the regulator to decide upon. I mean, if you're suggesting that really, if we open up the definition, it covers every bit of blockage, I'm not certain that's right.
That's certainly wrong, and that is the import of what Mr. Beale has been saying to
Well, I'm
you.
not certain if I'm not certain he is necessarily saying that, but if he did, then I think the retort would be, well, there's a lot of regulatory discretion as to what is going to be, what is sufficiently important as a blockage to result in a change in the way you allocate the costs. That may be a policy decision.
Well, look, the thread that runs through this from 2009 to 2019 in my submission is that congestion and congestion management in this context is concerned with that specific process of congestion management that happens by capacity allocation. And that is the auction process that you saw described in the annex to the 2009 regulation.
And that's in section 2 of the annex. It's very clear it's about international trade.
Precisely.
But the question is what changed between 2009 and 2019?
Well, what changed, my lord, is that that capacity allocation process ceased to be simply between individual member states and became between different bidding zones. And so the change in the language reflects that. It isn't suddenly opening up congestion to all forms of internal constraints within any given member state. It is still focused on those particular forms of congestion that are managed by capacity
Well, if that's what they
allocation.
intended to do, why didn't they say between bidding zones rather than between network areas?
My lord, I take that point and
Which I think was a point we debated in July.
we did, and my response to it was that this is effectively future-proofing. I mean, in circumstances in which you've seen 10 years of very dramatic change already in these markets, the language of network areas leaves open the possibility of such developments as there are. But what it certainly isn't saying is simply any place, anywhere in a member state. This is still about capacity allocation as a form of congestion management, as it took place in practical terms in 2009 and in the changed circumstances in which it applied in 2019. And your lords have the letter from Bayes to the parties explaining that from their perspective, the retained law definition remained appropriate notwithstanding the shift in regulations, because in practical terms in Great Britain they had the same effect. I simply made the short point there, my lords, as to what weight you place on that. It is an after the event submission by a government department, and to that extent it needs to be treated as a submission. But I say you can take it into account and place such weight as you think appropriate on it in those circumstances.
We'll certainly do that.
My lords, if I just take instructions. My lords, unless I can assist any further.
Thank you very much, Ms.
Good morning, my lords. I believe I can come in
I
hopefully
think we've probably
within the...
answered your question already, haven't we? As to whether or not there's a legal right for us to make a reference to the Commission.
Yes, well, in light of the indication that's been given, there's not really any point of me going over what's been said in the note. The only thing I would say, and you've got the note and what we say about it, in response to what Mr. Beale has said, is that the fact that GEMA was taking a decision within the transition period and was applying EU law doesn't answer the question of whether the decision falls within the terms of the Withdrawal Agreement, Article 5, such as to give rise to an obligation. It's a separate question, and we've addressed that in our note. But on the more general question about whether it's appropriate for the court to approach the Commission, we say with respect that it's not. Mr. Beale in his submissions referred to soft harmonisation. I suggest that what one is looking for here, or what's being proposed, is a soft reference. Unable to make a reference to the CJU to get your answer, we're looking around for the next best thing, which is a request to the Commission to find out what the Commission would do.
Pre decur.
But in my submission, and I agree with the submissions that have been made by GEMA, it's not relevant to know what the Commission's opinion is. That's not admissible. That's the first point. Secondly, there is limited, if any, relevance in knowing what the position is in other member states. That's the second point. And the third point is that insofar as the Commission might have wanted to come and urge a particular interpretation upon this court, they've been given an opportunity to do so, and they haven't. This is quite unlike the situation in Zwartveld, where the court was seeking to implement, through criminal process, EU law, and the Commission held relevant documents that were necessary for the court to fulfil that task properly. This is an entirely different issue. As I say, it's much more like a soft reference, where what one really wants is the opinion of the Commission, which unfortunately is not relevant. So I won't say any more about that. That's our submissions and our position on the soft reference issue. I can be very brief on the retained EU law issue. Just 2 points. First of all, it's worth bearing in mind, given this is a challenge, after all, to the CMA's decision, that the CMA at 8.60, page 710 of the core bundle 3, did not place reliance on the change brought about by the retained EU law amendments. They noted that they were consistent, but it wasn't part of their analysis. And secondly, and finally, the only other point I wanted to mention...
Is that a we have this conundrum, we've passed the implementation date, the EU retained law version now applies.
Yes.
Are you suggesting to us that we should simply ignore it altogether?
Well, no, I think there are two issues, aren't there? One issue is whether legally it can inform the interpretation of the recast regulation. And the submission by Mr. Beale is no, it can't, because how can the view of the UK executive have any bearing on the proper interpretation of the regulation? My submission is that's correct, and that the CMA did not place reliance on it for that purpose. Simply noted that the interpretation it had reached happily was consistent with it. Secondly, my final point, we endorse the view that a lot of the material that's been put before this court is not admissible and relevant on the question of interpretation. Internal documents and memorandum are not admissible aids to construction, and that principle applies as much to delegated legislation as it applies to secondary legislation. Sorry, as it applies to primary legislation. And just so, in case you want a reference for that, it's in Bennion, which actually is...
There's a passage in Bennion, isn't there?
There's a passage in Bennion in relation to, you have it, there's
It's in the authorities.
yes, it's in the materials referred to in GEMA note clip, at page 12 of that bundle, page 762 of Bennion, in the context of primary legislation. So it's page 12 of the clip, page 762 of Bennion, right-hand side of the page. This is in the part of Bennion, chapter 24, which deals with explanatory notes and other explanatory memoranda and so forth. And there's a heading towards the bottom of the page, other unpublished explanatory material prepared during the passage of a bill, matter of principle, other briefing documents, correspondence or material generated during the passage of a bill through the legislature should not be available as an aid to construction. There's a reference, footnote 17, to a judgment of Mr. Justice Sales, as he then was, which is at page 14 of the clip, in the Commercial Services Union case. And there's a paragraph of that case where Lord Sales, as now is, makes the point that you can't have an aid to construction that was not known to the people that were making not known to the public, and was not publicly available at the time the measure was introduced. And then just to make good that the same principle applies over the page, 788, the principle described earlier in this chapter in relation to interpretation of acts apply equally to the interpretation of delegated legislation so far as relevant. And then over the page 16, under the heading official statements, it makes the point that official statements may contemporaneously can be admissible aids, but obviously not internal, unofficial, non-public statements. So one does need to tread carefully when one is interpreting the materials, and although it may be interesting to see what people have thought about them at various times, they're not ultimately documents that can assist you in interpreting legislation. My lords, those are my submissions, unless there are any particular questions.
Thank you, Mr.
My Lord, may I very briefly make 2 points by way of reply? They both deal with the Commission issue. If the cri de coeur from this court is au secours, then it may well be that the Commission will listen carefully to that cri de coeur. That's all I say on that matter. Secondly, practical issue of delay. For your Lordship's information, CMP 308 has been approved by GEMA, and with effect from the 1st of April 2023, the CUSC charges will be imposed on demand, not on generators. There's been a regulatory change to shift the generation charges that are covered by the CUSC to suppliers, come what may. So there is a time limit of 5 months in which your Lordship's decision will have a practical impact domestically.
It all becomes academic
Yes,
in April next year.
yes.
Right.
But there is, of course, the historic position,
Of course, we understand.
which is worth some money. That's all I will say, unless I can insist further.
Mr. Beale, just about within the hour and a half.
Yes.
Right, well, thank you all very much. The reasons I won't elaborate in reserving judgment. You'll get the draft judgment in the usual way for typographical errors and the like, not for re-arguing points, please. Please pay particular attention to the terms of the embargo that's on the front of the judgment. You're probably aware there have been some high-profile lapses over the last few months, which this court is very anxious not to have repeated, because we don't want to go back to the old system where you've only got the draft judgment 5 minutes before hand down, or whatever it was, an hour before hand down. So just pay attention to that, if you would. Can I just finally, on behalf of the court, say thank you to all of you and to those behind you for all the assistance you've given me. It has not been an easy, but nonetheless a very interesting case. Thank you.
For us.